Kelsey Fitzsimmons and her team filed their brief to the full panel of the SJC this past Monday. It's super long, so I'm not going to read through all of it, but I am going to go over the summary of facts and the summary of argument. I might not get to all of that in this video, but I'm going to start with the summary of facts. On June 30th, 2025, appellant North Andover police officer Kelsey Fitzsimmons was shot in the chest by a police colleague from just feet away after North Andover police appeared at her home to serve her with a restraining order. The order was just obtained by her fiancé ex parte from the Essex probate court, requiring Miss Fitzsimmons completely without notice to give him custody of her 4-month-old, forfeit her firearms, and consequently forfeit her job, her upcoming wedding, and her relationship. The shooting occurred in her bedroom in North Andover, Massachusetts. Miss Fitzsimmons contends she obtained a firearm to engage in self-harm as a result of her entire future crumbling on the spot. She contends she would never point a gun at a fellow law enforcement officer, much less the officer who she considered to be a friend. The alleged victim officer contends appellant tried unsuccessfully to operate the firearm intended to shoot him, causing him to shoot her. There were no body cameras and no other witnesses to the events in the bedroom. On August 7, 2025, after 38 days in Massachusetts General Hospital, appellant was arrested, handcuffed, and shackled to her hospital bed. Ms. Fitzsimmons was arraigned on the 3 foregoing charges out of Lawrence District Court from her hospital bed via phone on August 9, 2025, and held, following a written motion by the Commonwealth. The charges were presented to the Essex County Grand Jury on August 25, 2025, where the grand jurors returned a true bill on only one count of assault by means of a dangerous weapon. Appellant was arraigned in Essex Superior Court, Salem, for the single indictment on August 28th. Despite the drastic reduction in the charges and the eligibility for probation, held Ms. Fitzsimmons pursuant to the Dangerousness Code after a motion filed by the Commonwealth. On September 8, 2025, after filing several motions, appellant was released on maximal conditions including GPS bracelet, residing at her mother and stepfather's residence, no possession of firearms or dangerous weapons, no alcohol, scram alcohol breath test device, 24/7 house arrest with 48 hours notice to probation for attorney/medical appointments, no contact with the witnesses, and no contact with her infant son regardless of future rulings on the subject made in the pending probate and family court. On September 10, 2025, appellant filed an emergency motion for immediate relief from the scram order. Ms. Fitzsimmons filed an affidavit with her emergency motion outlined for the court that I am required to blow into a scram device 3 times a day. Each time I attempt to use the scram device, it takes a minimum of 4 to 5 times of blowing due to the amount of breath the device requires to register. Each time I blow into the device, it causes me extreme pain due to my broken ribs and the fact that my lung has not completely healed from being shot. I have also developed significant anxiety that my inability to blow into and complete each test will trigger a warrant for my arrest. I feel that putting my body through the exertion this test requires is causing major setback to any healing progress I have made. Appellant's mother also provided an affidavit to the court stating, I witnessed her struggling extremely with blowing into this device. There was one occasion where she almost passed out. After that occasion, she became very shaky and sick for most of the day. The parties appeared before the court, McCarthy-Nyman, the next day, and appellant requested alternatives for scram testing. What should have happened could have taken 5 minutes, where the defense reported difficulties and had an alternative method of alcohol testing put in place. Instead, a completely improper nightmare scenario played out. Rather than utilizing a readily available, common alternative method of alcohol testing, the court surrendered the appellant back to jail without a request to do so from either the Commonwealth or probation. The court shut down the probation officer, cut off counsel, and walked off the bench while undersigned was arguing for his client. In writing, she accused the defense of manipulating the situation and repeatedly misstated the record. Just hours after the court's unexpected revocation order, undersigned filed on the same day a motion to reconsider and attached emails from probation to confirm alternative testing. On September 15, 2025, appellant filed a supplemental exhibit for her pending reconsideration motion that included a very difficult to obtain letter from her trauma surgeon corroborating the prospect of Ms. Fitzsimmons' claims of pain while breathing deeply into the scram device. Nonetheless, on September 16, 2025, the court issued an order denying defendant's motion to reconsider imposition of custody and for reinstatement of original terms of release with order for alternative testing. Ms. Fitzsimmons filed an emergency petition for release from order revoking terms of release brought to the single justice of the Massachusetts Supreme Judicial Court. The single justice denied the petition without a hearing. Ms. Fitzsimmons now petitions the full court for relief pursuant to the SJC Rule 221. Summary of argument. The trial court's actions are indefensible in the circumstances at bar. The decisions abuse the concept of dangerousness and, if allowed to stand, will seriously dilute the high standard previously solidified in case law. Even if dangerousness is proven, incarceration is the last resort, especially for a police officer and former corrections officer, and only then by clear and convincing evidence. These constitutional and case-based guarantees are not merely optional formalities. Here, such a finding is chilling, heartless, and legally baseless. The trial court discounted so much to get the case to where it is. Kelsey Fitzsimmons is a sworn law enforcement officer from 2 different Essex County agencies. Far from posing a danger, she has passed the many hurdles to become an officer, sworn an oath, and has been entrusted by the community to protect them from danger. She has an insignificant record from 2018 that had no effect on securing her law enforcement career, and a clean record in the Essex County law enforcement. Her service as a public safety official, proudly protecting those in her town and in her county from danger, putting herself in harm's way, was all but ignored by the trial court and is strong evidence in her favor. The nature of this incident is also inconsistent with the requirements that there be clear and convincing evidence of some ongoing risk of future danger. On the Commonwealth's allegations, Ms. Fitzsimmons assaulted the officer with a gun in the course of attempting self-harm due to a complete collapse of everything important to her at that moment. At best, on the Commonwealth's allegations, the officer was placed in apprehension in the course of events that had nothing to do with him personally. There is no animus or motive to harm him going forward. In fact, the record points in complete opposite direction. Ms. Fitzsimmons publicly stated that officer was not just a colleague, he was my friend. That officer and I experienced a very difficult and sad call for service together last summer. That call for service that day was a true tragedy and caused this officer and I to build a friendship due to experiencing it together. To this day, his support during that hard time is something I'm still grateful for, regardless of this recent incident that occurred. There is no likelihood that Ms. Fitzsimmons, stripped of her firearms, a bit over 5 feet tall and 110 pounds, who can barely take a deep breath, would put that SWAT-trained armed officer or anyone else in danger going forward. She is gravely injured and presently scheduled for her 5th operation. She should benefit from reasonable accommodations under the Americans with Disabilities Act rather than be housed in a prison cell. Alcohol was an irrational focus of the trial court. There is no likelihood that alcohol consumption is a real factor here. The incident had nothing whatsoever to do with alcohol. Drinking the weekend before at her bachelorette party is hardly a bellwether of whether alcohol abuse by a new mother and a full-time sworn police officer. Her serious ongoing medical struggles all but rule out alcohol abuse and manifestingly do not require any unyieldingly approach to alcohol testing. She should not be required to satisfy phantom concerns, and if the court for some reason deems such testing necessary, she can easily drive 10 minutes down the road for urine testing rather than being tortured with constantly reoccurring breath tests. The lower court should be reversed, at the very minimum, not result in Ms. Fitzsimmons' incarceration.